Hello. The following information is being presented as part of the Governor Mifflin Area Citizens Academy that was developed by the 5 communities and school district in the Governor Mifflin area. The 5 communities in the Governor Mifflin School District include Brecknock Township, Cumru Township, Kenhorst Borough, Moulton Borough, and Shillington Borough. The following information is being presented in order to provide you with a better understanding of the organization and operation of the local units of government in the Governor Mifflin area and to help you become more involved in your local community. We hope you find the material helpful, and a copy of this recording may be obtained at any of the municipal offices or the school district administration building. The Governor Mifflin Area Citizens Academy is made possible through a grant from the Russell L. Hiller Charitable Trust Fund of the Berks County Community Foundation.
Good morning. I'm Doug Rauch. I'm an attorney with the law firm of George Addis Setley. I've been practicing law and specifically municipal law in Berks County for about 20 years. I'm here today to talk to you about Pennsylvania's Sunshine Act and the Right to Know law. I'm going to begin with the Sunshine Act. The primary purpose of the act is to ensure openness and transparency in the democratic process, to afford citizens the opportunity to observe the deliberations, the policy formation, and decision-making processes of the governing bodies. The Act allows us to have faith in our governing bodies in how they govern and ensures accountability of those people that we elect to do the government actions that they undertake. How does the Sunshine Act work? The Act applies to all government agencies. An agency is defined as a body that takes official action or renders advice on matters of agency business. It's what you might think, your city councils, your borough councils, township supervisors, county commissioners, and school boards. But it also includes trustees of the boards of state-related colleges and universities and any other kind of statutory created organization which has as a purpose, a primary purpose of carrying out an essential government function. All of them qualify as agencies. An agency takes official action by establishing policy, making decisions, and voting by voice votes on ordinances, resolutions, and the like. It's important to note that just because, for example, if 3 of the Berks County Commissioners show up at a Reading Phillies baseball game, there's not a violation of the Sunshine Act because they're not taking official action. Official action and deliberations on official action must be held at a public meeting. Deliberation is the discussion of agency business for the purpose of making a decision. A meeting is defined as a prearranged gathering of the agency attended by a quorum of its members for the purpose of deliberating and taking official action. Thus, official action and deliberation by a quorum of members must take place at an open meeting unless it falls under one of the exemptions of the Act. What are these exemptions? Agencies can go into what's known as executive session, private confidential meetings to discuss agency business. However, the result of that executive session must be proclaimed in public. The Act enumerates the exceptions, and it's what you might think. If the agency needs to discuss its personnel, employment matters, if it wants to discuss the strategy and negotiation of a collective bargaining agreement, if it wants to consider the purchase of real estate, all these things can be taking place in public or in private. If the agency wants to discuss litigation with its solicitor, if they need to discuss matters which otherwise are lawfully privileged or confidential, and with respect to state universities, of course, admission standards and academic progress can be discussed in private. How's it done? An executive session can take place during the public meeting or after it, or at some other time. If it is going to be held at a time other than the night of the meeting, that also must be advertised in 24-hour prior notice to citizens so they can attend. The purpose of the executive session must be proclaimed either before or after the meeting. As I mentioned before, the Act does require public notice of meetings. This is done by placing an advertisement in a paper of general circulation in the municipality, in the area where the meeting is going to take place. It can also be done by posting notice of the meeting on the building where the meeting is going to take place. Again, the notice must appear 24 hours prior to the meeting. The notice has to state the date, the time, the place of the meeting. And it is sufficient for a municipality to advertise all of its regularly scheduled meetings for the year at the beginning of the year in order to save advertising costs. However, that advertisement must appear at least 3 days before the first regularly scheduled meeting. There may be occasions where there would be emergency meetings called where the municipality meets without giving 24-hour notice, but there must be a clear and potential danger to life or property. These emergency meetings are very rare. With respect to the business of meetings, all votes must be voice vote. There's no paper ballots. Minutes must be taken at public meetings. The minutes got to include the date and the time and the place of the meeting, and the quorum, the members that are there for the quorum, action that takes place, and records the names and what those people spoke about of people who are there to make public comment. All citizens must be given a reasonable opportunity to speak about official action taken at the meeting. The Act requires it to be before the taking of official action, so most municipalities have their public comment period at the beginning of the meetings, although some take public comment before each vote. An agency may have rules restricting public comment, such as asking for sign-in sheets and placing reasonable limits on the length of time that you want to speak. And agency members are not required to respond. It's not a question and answer session, but very often board members do respond to questions that come up at public comment. So long as there's no disruption, people who go to public meetings can record the proceedings. If the Act is violated, any action that takes place can be invalidated. But the violations that are generally innocent violations can be cured by ratification of official action at a subsequent publicly duly advertised meeting. I want to talk a little bit about the right to know law. The right to know law, the so-called open records law, originally was enacted in 1957. It's gone through numerous changes over the year and some sweeping changes in 2009. Its basic purpose is to provide public access to public information. The law provides rules for all public agencies in Commonwealth of Pennsylvania. A local agency is what you might think. It's a political subdivision, intermediate unit, charter school, schools, townships, boroughs, city councils. A public record is a record, including financial record, that's not exempt under the Act or exempt under any other federal or state law or subject of a judicial order. A record is defined as information regardless of its form or characteristics that documents transaction or activity of a local agency. This includes documents, maps, ordinances, resolutions, books, tapes, films, recordings, and information stored electronically. All these things are subject to public access. Local agencies are required to provide public records under the Act, and they can't ask of the person making the request the intended use of their documents that they're asking to review. A record in possession of a local agency is presumed to be a public record and therefore subject to these disclosure rules, unless it's subject to one of the exemptions, which I'll get to in a little bit, or other privilege, or a judicial order prevents it from being disclosed, or another federal or state law prevents it from being disclosed. The right to know law requires all agencies to designate an official or an employee as an open records officer, and this is the person that you would go and contact if you wanted to get copies of any public record. The open records officer is the person who receives the request, tracks the progress of the request, and eventually makes a decision either granting or denying the request. The right to know law permits the local agencies to make rules and regulations how the requesting process is to take place. The right to know law also created a new Commonwealth office, the Office of Open Records, which handles appeals from citizens who've had their requests for documents denied. The agencies are required to post at the agency the name and address of the Open Records Officer in the Office of the Open Records. Although the agency may designate its own form, its written form, in which you would fill out in order to get a document, the Office of Open Records has created its own uniform form, if you will, which has to be honored by all agencies in the Commonwealth of Pennsylvania. An agency may deny disruptive request if a person requests the same document over and over again and it becomes an unreasonable burden. They also may deny request if there is a problem with the extent of the request, or if it's not timely because of some natural disaster or a flood, a fire, or something to destroy the records, they can't produce it. Agency records that are not in possession of the agency, but are in the possession of a third party that the agency has contracted for to carry out an essential government function, those records also are disclosable. A public record must be provided in the medium requested, but if it exists in that medium, you don't have to create a record that doesn't exist. Requests for documents may be verbal or written, but if you make a verbal request, you won't avail yourself of the remedies and relief that the right to know law provides if you put your request in writing. Requests may be submitted to the Open Records Officer in person, by mail, by fax, by email. Written requests must be addressed to the Open Records Officer and must identify with specificity what records you want, so that two things, that the municipality can determine whether they have the record, and number two, whether it's a, quote, public record. An agency, as I mentioned before, cannot require a reason from the person making a request why they want the documents, and they can't ask of the intended use of those documents by the person making the request. And again, an agency does not have to create a document which doesn't exist, and it doesn't have to reformat a document it already has into the form that you want it. Some documents requested may have a combination of both public and private information. The local agency is required to redact or black out those portions of the document which are containing the non-public information. I mentioned the exemptions. There are 30 exemptions to what is a public record, and I'm not going to read all of them. There's subcategories, but it's what you might think. A record which would have the likelihood of endangering the safety or physical security or public utility, relating to computer hardware or source files, a record containing all or part of a person's social security number, their driver's license number, personal financial information, personnel records, ratings, reviews, an academic transcript, a record that constitutes trade secrets, records relating to results of a criminal investigation, DNA records, library and archive circulation records, and records of information relating to communication between an insurance company and the local agency. These kinds of things are examples of the exemptions, and I'm not going to go into the rest of them, but those things would not be subject to disclosure under the right to know law. So the procedure. Upon the receipt of a request, the agency must determine whether the record is public and whether it has the record. The agency must respond in 5 business days to the request, otherwise it's deemed denied by the agency. The agency can receive an extension if within those 5 business days they go to the requester and ask for additional time. They have up to 30 days. After that, it's deemed denied. And the reasons for a request extension might be they want the matter to be reviewed to their solicitor to review whether what's being requested really is a public record, or maybe the record has to be redacted. If the staffing at the local municipality is such that it can't adequately provide the documents within the 5 days, and sometimes the extent of what is requested is so large that a response can't be done within 5 days, those will all be legitimate reasons for getting an extension. If the agency fulfills the request and the person making the request doesn't come and pick up the documents that it's requested within 60 days, the agency can discard them. If the request is denied, the agency, in its response, must give the reasons why it's denied the request for the document with some legal authority backing it up. They also have to give the procedure to appeal to the right to know law to the person whose request has been denied. If a written request is denied, The requester may appeal to the Office of Open Records within 15 business days of the denial. The appeal has to include the reason why the person making the appeal thinks that the public record is a public record, and also has to address the reasons that the agency gave for denying the record. The Office of Open Records makes its final determination within 30 days of the receipt of the appeal, otherwise it's deemed denied. Within 30 days of the mailing of the Office of Open Records decision, either party can appeal to the Court of Common Pleas in the county where the municipality is located. I did mention fees. Fees may be charged for duplication costs. They must be reasonable and comparable to what's being charged locally, although there may be regional differences. Fees must be paid before the documents are turned over, and the agency may require prepayment of fees if it's expected that the cost of duplication is going to be greater than $100. However, the agency cannot place any limit on the number of records requested for inspection of duplication. So as you can see, the Right to Know law and the Open Meetings law encourages the participation of citizens in the government. As the former Speaker of the House, Tip O'Neill, said, all government is local. Pennsylvania's Open Records law and the Sunshine Act encourage you to get involved with your local government. Thank you.